Welcome to today's program titled Europe, Spain and France, What's New in the Employment Landscape. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials along with the CLE attendance form will be distributed to attendees in the days following the webinar. On the next slide, you will see our legal disclaimer. This presentation has been prepared by Seyfarth LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to Martin Hopkins, my colleague who will serve as the moderator for this webinar. Martin, go ahead.
Thank you very much indeed, Megan. Good morning, good afternoon, good evening to everyone. As Megan said, my name is Martin Hopkins. I'm going to be your moderator for this session today. So that has me responsible for timing, making sure that we get to the end of the program on schedule, and also what I would call crowd control in terms of Q&A management. Obviously, if you do have any questions as we run through the program this afternoon, please post them on the platform. I'll monitor those as they come in. We'll try to leave questions until the end of the program, but if I see anything that I think needs to be picked up by either of our presenters immediately, we can easily enough do that. So what we're looking at today is the way in which two of Europe's largest economies are tackling some of the strategic challenges that are affecting workplaces all around the world. To help us do that, we've got two speakers from our European-based team. Megan, if you can flip over to the picture slide, thank you. So we have Anna Sid, who's one of our international L&E specialists, who works from her home base in Spain on projects across Europe, Middle East, and Latin America. And Lawrence Harvey-Wood. Lawrence is a dual qualified and also a dual national English and French lawyer who spends his time helping international businesses as they navigate the maze that is French labour and employment law. If you could click the slide again, please, Megan. So these are the four topics that we're going to be talking about this afternoon. So firstly, the gig economy, what's going on with that. Secondly, remote working practices and regulations. Thirdly, developments in gender pay equity regulation. And finally, this will probably be the smallest of the four sections, some news on lockdown rules as they are in flux in Spain and France as well. So without any further ado, I'm going to turn it over to Lawrence. Lawrence is going to kick us off by talking about what's going on in the gig economy. Lawrence, over to you.
Thanks, Martin. Hello, everyone. So what do we mean by the gig economy? We're really talking about working relationships where typically the worker is paid by the task, not the hour, and above all, where neither party has any significant obligation to provide or perform work on a durable basis. The focus today will be specifically on digital platform work, app-based companies that provide, let's say, taxi or delivery services typically. Companies like Uber, Uber Eats, Deliveroo. Now, drivers and riders who work for these companies generally sign standard terms and conditions which state that they'll operate as independent contractors. The company effectively positions itself as an intermediary between the end user and the freelance service provider, charging a commission in order to put the two parties in contact. But in reality, the platform operator may contain a considerable level of control over how riders perform their work. So control in terms of the price to be charged to the client, the worker's hours of availability sometimes, geographic area to be covered, and so on. And there may also be consequences if gigs are repeatedly not accepted by the rider. Or, for example, a driver rejects 3 rides, then they may be temporarily disconnected from the platform. So recently, drivers and riders have brought court claims in various European countries in order to try to obtain employee rather than independent status. And the latest court decisions in Belgium, France, Italy, Spain, and the UK give the impression that courts sometimes find it difficult to analyze gig-based work according to the traditional criteria for deciding whether a working relationship is an employment or not. Today, we're going to talk about some of those decisions. Before that, I'd just add that the European Commission recently opened a consultation with the social partners on how to address challenges relating to working conditions in what they call platform work. And possible measures mentioned by the consultation paper include introducing a rebuttable presumption of employee status, or alternatively, reversing the burden of proof so that it would be up to the platform to prove that its workers are not employees. Anyway, the Commission aims to present legislation by the end of the year, I believe. In parallel, just last week, the French government adopted an order providing for the creation of a system of collective representation for independent workers in the digital platform sector. So next year, these workers will be able to actually elect representatives to engage in negotiations at national level with the platform companies, and the platforms will have to finance this new regime. Let's move to the next slide, please, and look at the most recent court decisions in France in this area. So a bit of background: the traditional test in France for employee status relies upon the notion of a link of subordination, and according to established case law, this link exists basically if the worker performs their duties under the instructions and supervision of the company and can be sanctioned for poor performance or for doing something naughty. So if we start in 2018, French Supreme Court upheld a claim against a food delivery company called Take Eat Easy on the basis of this test, deciding that the claim was in fact an employee. And the court relied in particular upon the way the Take It Easy app worked. So once it was installed on the rider's phone, it allowed the company to track his movements and measure the distances traveled and so on. Then in 2020, the Supreme Court ruled in favor of a number of Uber drivers. And this time, the court took into account the fact that the taxi service was entirely organized by Uber. So the driver couldn't build up his own clientele, couldn't decide what price to charge the client, and couldn't even decide which route to take. And in addition, Uber had the right to disconnect the driver from the platform if he refused a certain number of rides. But with that said, the question of employee status for platform workers in France is not totally clear. It really depends on the facts. So, for example, there are 2 very recent decisions concerning another food delivery company called Deliveroo. In February, the Paris Labour Court ordered Deliveroo to pay damages for concealed work to a rider who was paid by the hour, because it ruled that in reality he was an employee, and indeed the court called it a fraudulent avoidance of the Labour Code. But just a couple of weeks ago, the Paris Court of Appeal decided that a different Deliveroo rider was an independent contractor, and it relied on various factors. In particular, the rider was free to accept or refuse work. He was allowed to work for competitors, and he actually did so. That wasn't merely a theoretical, on paper sort of right. And he was also allowed to subcontract the work. Now, it's worth noting that Deliveroo's conditions seem to have evolved. The earlier case actually dated from 2015 originally. The more recent case where Deliveroo succeeded was different in various ways, in particular payment by the gig, not by the hour. Anyway, we will have to wait some time to see what the Supreme Court makes of those 2 decisions, if they are appealed all the way to the top. Meanwhile, I'll hand you over to Anna to talk about Spain.
Thank you, Lawrence. So the situation in Spain is somehow very similar to France, although the balance has recently moved towards the employment nature of the relationship. The traditional test that Lawrence described for France is practically the same in Spain. So whether this rider will be considered an employee or an independent contractor will depend on the managerial powers that are exercised by the company. So if this digital platform is supervising, is giving instructions, is controlling the way they do the work, and also imposing disciplinary actions, then it will be considered an employment relationship, where if it doesn't, then it will be a genuine independent contractor. We have seen, and also based on facts, as Lawrence was explaining for France, we have seen initially different case law from the social courts in Spain. Some of them ruled that this was a genuine independent contractor because they were free to decide the times when they wanted to work. They were providing the tools for the rendering of the services, and also basically they were able to accept or refuse some services. Others decided that, or have ruled that this was not really an independent contractor relationship because the rider was actually subject to some sanctions or consequences if they rejected the service. Also, the freedom to choose the hours to work was not such because they were also subject to some worse conditions if they, or worse rating if they rejected the services in a particular time frame, that is where more services are being requested. And also, the key tools is basically the clients. So the clients were provided by the platform, and then the rider didn't have any ability to influence on those. And that leads us to the decision taken by the Supreme Court in September 2020. In Glovo case, Glovo is a digital platform that delivers all types of products. And in that case, the Supreme Court has analyzed the way they work and the way they operate, and the conclusion was that this has to be considered an employment relationship because of basically, as I said, similar to what some lower social courts decided, there was no real freedom for the rider to choose timing when they wanted to work, because that meant that they get a lower rating. And that rating also, together with the evaluation or the assessment that the clients do, was considered a genuine employment evaluation. And that was also considered kind of somehow a disciplinary powers that the platform was doing into the riders. And also another relevant topic that was analyzed in this case law was that the rider didn't have any ability to negotiate pricing and didn't get payments directly from the client. Payments were done to the platform, and then the platform would reward and give whatever fees agreed to these riders. So following this case law, we have seen an increase of litigation. Actually, labor inspection has been quite active, and we've seen cases with a high number of riders involved. So for instance, one case law that was published in January this year, in January 2021, declared, after an inspection from the labor inspection, declared that 748 individuals in Barcelona were actually considered employees and not independent contractors. This is not final, it's subject to appeal. Like in France, it depends on the facts. So actually, if the facts change, we might see some other case law taking other solutions, other decisions. But the fact is that following the Supreme Court decision, we kind of see this quite likely to move towards the employment relationship as opposed to independent contractors. And then finally, over this time, government has been taking action and has been negotiating with the employers' representatives and the unions and employees' representatives to the proposal of what is called the Riders' Law. This Riders' Law is not final. It hasn't been approved. It's more, what we have seen so far is just a proposal. But it follows the lead of what Lawrence was describing, that is the initiative taken by the EU on this rebuttable presumption of employment services. this proposal says is that any activity rendered by individuals in delivering or distributing products under the organization, direction, and control, directly or indirectly, by a digital platform will be considered employees. So this is, again, an assumption that any writer working for a digital platform will be considered an employee, but again, subject to proofs on the contrary. So the burden of proof, again, is moved, but it will be assumed, and all the kind of forces are to consider these individuals, writers, as employees and not as independent contractors. More to come on this topic, I'm sure. But moving on to the next topic of today, we're going to discuss a little bit about remote working. Can we move to the next slide, please? Remote working has been the hot topic throughout the pandemic, but now after the pandemic, well, not after, in these more developed stages of the pandemic, we are seeing more and more countries regulating remote working outside of such context of COVID-19. And we've also seen, and let me touch on this very quickly, employees requesting employers to work from different countries. So this is what we call the cross-border remote working. I'm not gonna discuss, or we're not gonna talk about this a lot today because basically this would be subject to another webinar. We could be talking quite a lot on the different issues that this raises, but I just wanted to mention that because Spain is actually one of those countries where employees sometimes have requested to work remotely, even though their contract was with a company located somewhere else. These can trigger implications from a tax, corporate, immigration, and data protection standpoints, and therefore local laws might be applicable and they have to be looked at before entering into this, lovely and attractive remote working from different countries. But going back to the in-country remote working, we have seen different countries in Europe implementing remote working regulations to cover, and the consistent topics that have been applied are: how do we protect health and safety of the employees working remotely? What is the contribution that the employer has to take towards the expenses and the tools that they need to render the work? Also, do we have to introduce an amendment to the employment agreement, or is just the company policy enough? And then finally, how do we protect confidential and data privacy information? Spain has been one of those countries that has ruled the remote working in a quite detailed way. So if we move to the next slide, let me tell you a little bit what the Remote Work Act has been for Spain. Pre-COVID-19, the legal framework was just quite general, and it covered, basic regulations with minimum rights in terms of voluntary nature of the remote working, some rights in terms of training, employee representation, etc. But basically, it was subject to whatever the parties agreed. COVID-19 provided for some regulation on mandatory home working whenever possible, but that, as I said, it's exceptional. What was approved in September 2020 was a new act that rules in quite level of detail how remote working has to be set up in Spain. And as I said, it doesn't cover the exceptional measures for COVID-19 remote working. Actually, the law expressly says that COVID-19 home working is not subject to the law, provided that all the expenses and tools are being covered by the employer. So this regulation, as I said, is quite detailed, but the three pillars that guide the principles of the law are, first, equal treatment for remote employees. And this is important because there cannot be different treatment for any individual who is working remotely compared to any individual working in the office. And this means that, you cannot pay less to the employee that is working from home or in a different location as opposed to the one that is going to the office every day. That is expressly provided by the law. They cannot have different treatment based on the fact that they're working remotely. The second pillar is the voluntary nature, and this is key. And we will see now that one of the obligations that the remote work covers is the obligation to have remote working agreement, where the terms of the remote working are agreed individually between the parties. that means that, you know, the mandatory home working of COVID obviously is not included because that was mandatory. And then secondly, if the parties agree that the employee is going to work in the office, the employee cannot unilaterally say, I want to work from home, or company cannot unilaterally say, I'm going to close the office, everyone will work from home from now on. That has to be agreed individually with the employees and has to be, you know, trigger the consent of the parties, both employer and employee. And then the final one, and it's also quite important, is the relevance of collective agreements and employee representatives agreements that will cover the main aspects of the relationship. And here, for the audience that is not used to operate in Spain, let me briefly explain that collective agreements are a source of law in Spain, and basically every company, every employment relationship is subject to a collective agreement. That doesn't have to be negotiated by the company. That doesn't have to be negotiated with the company employees. These apply to the industry where the company is rendering services, where the company develops activity, and they vary. In some industries, they are at national level. Other industries would have a regional collective agreement for Madrid or for Catalonia or for the province of Barcelona. Depends on the scope. But there will always be kind of this minimum, as I said, source of law that covers minimum regulations that apply to the employment relationship. If we can move to the next slide. So the main obligations under the Remote Work Act are, as I said, obligation to have a remote working agreement. And the remote work agreement has to cover the content that is expressly provided by the law, listing the necessary tools, the compensation of costs, the working schedule, whether this will be full-time or part-time, and the law expressly defines what is considered remote working, and it has to be more than 30% of the time in an average period of 3 months. And also the location has to be defined between the parties, so the employee and the company have to agree where the services are going to be rendered. And if that has to be modified, then again, subject to the agreement of the parties, the duration of the agreement, then parties can agree if this is permanent or if this is for a certain period, and also the possibility to reverse the agreement and go back to the office work. So parties can negotiate if, you know, with 1 month prior notice, the company or the employee can reverse the agreement and go back to the in-person work. And then also some other types of, you know, ways to monitor and control work performance for the employee working remotely. As an additional obligation, it is mandatory to serve a copy of this remote working agreement that, by the way, it can be a separate agreement executed between the parties, or this can be included into the employment contract. So if you have a new agreement, a new employee, and you know that that employee will be working remotely, the content that the law mandates for the remote working can be included into this global employment contract. It doesn't have to be a separate agreement. And then this, as I said, the copy of the agreement has to be served to the employee's representatives whenever there is one, and to the labor authority as well. And the law also provides for certain areas to be covered in the remote working relationship, like training and professional promotion, employee representation rights. The company has to guarantee that there is communication with the employees' representatives and those employees working remotely. Working hour tracking system, again, for those of you who are not operating in Spain on a daily basis, just a reminder that it is mandatory in Spain to track working hours every day. The start and the end of the working hours have to be tracked daily. And therefore, the tools and the reliable method to track working hours have to be implemented for remote workings as well. Also, obviously, how to protect health and safety of the employees working remotely. And the policy to exercise, and this is relevant as well, the right to disconnect digitally. So employees working remotely cannot be permanently connected to work. The employer has to negotiate with employees' representatives the way and measures to allow them to disconnect and not be permanently online. And that is also an obligation for the employer. And then finally, as I said, if the company wants to execute any monitoring tools or any specific process to supervise work performance, that also has to be expressly provided and ruled, either negotiated with the employees' representatives or ruled in the remote work agreement. The truth is that for now, we don't really see in collective agreements rules for remote working because this is quite new, but we expect to see this in the future because of the mandate of the law. We expect to see quite a lot of developments in collective negotiation to cover expressly what are the rules that would apply to remote working employees, how much the compensation of the tools or cost or equipment has to be, paid to these individuals, and lots of other areas that are subject to discussion and negotiation at the moment. And that's it for Spain. I'm going to pass it now to Lawrence to tell us a little bit how the remote working is being developed in France lately.
Thanks, Anna. So I think if you look at existing pre-COVID statutory rules for remote work, or télétravail, as we call it in France, there are two key points. First of all, I would say the labor code provisions are a bit odd because they say you must implement remote work by negotiating a collective agreement at company level or else adopting a unilateral charter. But then the labor code says if you don't have either of those, you can basically do what you want on an ad hoc basis. And so in the past, in practice, most French companies, they would just sign individual contract amendments with the relevant employees rather than adopting any kind of collective charter, policy or agreement. And since COVID, for the moment, the French government hasn't sought to legislate in this area. They've just recommended generally that people work from home as much as possible, of course. And I think recently advised that companies should let staff do so at least 4 days a week if possible, but this isn't binding. In parallel, in response to COVID, there is a new national interprofessional collective agreement on teleworking signed in November last year, but it's pretty soft, sort of aspirational in content, nothing much in the way of binding rules. In practice, recently, we've had a number of clients asking whether the employer has to pay specific expenses or compensation or an allowance to home workers, and I see some questions about that today. In France, first of all, there's a general obligation to reimburse all employees for legitimate work-related expenses, and that includes remote working expenses. So potentially that would include internet subscription if your employee tells you, well, I don't have an internet subscription, so I'm going to have to get one. Secondly, there's a case law requirement saying you have to pay compensation to home workers for the inconvenience of giving up part of their home for work purposes, but that's only if the remote working is at the request of the employer, and generally people don't think that that applies to temporary COVID-related measures. In practice, in our experience, before COVID, it was quite common in France to pay a fixed monthly allowance of, say, 50 or 75 euros to cover remote work expenses. And it's not a bad option because there's a limited exemption from Social Security contributions if you do that. So for someone who works 5 days a week from home, I think you can pay up to 50 euros a month, and it's free of social charges. More recently, our impression is that most companies haven't yet started paying monthly allowances to people temporarily working from home due to COVID. I think people are waiting to see what the new normal looks like before changing their home worker policies. And I think that's probably not specific to France, but it's what people are doing generally. Let us move on quickly to our third topic, gender pay equity, and back to Anna.
Thank you, Lawrence. So if we can move to the next slide, please. We're going to talk about the pay equity developments. We've seen in European countries lots of regulations in terms of obligation to measure and report gender pay gap. Often there is no binding requirement to take action and reduce the gap, but that is not so much the case for Spain, and I'm going to explain in a minute how that has been implemented. The equity law, actually this is not a reason, the equity law was approved back in 2007, but there was a reform, there was a modification on this law that was enacted last year, March last year, actually with International Women's Day. On March 2020, this law was modified, and in what applies and what refers to pay equity, there are two aspects. One was the extension of the obligation to have an equity plan for more companies. Initially, this was only mandatory for companies with more than 250 employees, but what the law said is like gradually, over 3 years, this would be extended up to companies with more than 50 employees. So it was 150 employees in 2020. This year, it was with companies with more than 100 employees. As of March 2021, they have to have an equity plan. And then as of next year, it will be 50 employees. The equity plan includes various obligations to gather diversity information in terms of gender. So what are the professional groups or jobs with higher or lower representation, generally for one gender, generally female gender, and to address, there needs to be a diagnosis and an analysis of the company, and this needs to be negotiated with the employees' representation. But importantly, that equity plan also has to cover what is called the gender pay audit. So company has to analyze and carry out a gender pay audit, including an evaluation and diagnosis of the relevant job positions and professional groups. And also, if there are other factors that are affected, the lack of representation of one or the lower representation of one gender or the other, in subject like, limiting the promotion or any other aspects that might affect the different pay. So apart from that, the pay audit has to include, and that is important, has to set up an action plan with measures to mitigate whatever issues that have been identified, and also follow-up actions to implement whatever improvements that have been agreed in the framework of this equity plan. But other than that, there is an obligation for all companies, so even those companies that don't have the obligation to have an equity plan, they have to have what is called the Equal Pay Registry. This Equal Pay Registry that actually is in force as of less than 2 weeks, as of 14th, 2021, has to cover the average salary that applies in the company for all groups of employees. And they have to be disaggregated per gender. So the average salary for group 12, female and male. And that has to cover both basic salary, complements, and also any extra payment that is non-salary nature has to be covered as well. And when I say all professional groups, I mean all, because this applies from the lower groups up to the senior executive levels. So top managers also have to include the average salary in this Equal Pay Register. The Equal Pay Registry has to be prepared every year. And if there are any substantial changes, then it should be updated. And it should be available for the employees' representatives. So the employee representatives will have access to it. In companies without employees' representatives, the employees themselves might request some information, obviously not the whole register, but they will have the right to see the percentage in the gap if there is one. So that kind of basic information needs to be provided. And then importantly, for companies with more than 50 employees, the law provides, actually this was a modification in the Workers' Statute, that in such companies with more than 50 employees, in case there is a gap of more than 25%, the company has to provide a justification for such gap. So, and justification obviously the justification cannot be gender. It has to be an objective and legal reason to explain why there is such gap of more than 25%. And now I'm going to ask Lawrence to tell us a little bit what is the pay equity regulations for France.
Thanks, Anna.
Before we do that, Lawrence, Anna, can you just confirm those numerical triggers, 100 or 50 employees, are they individuals employed in Spain, or if the entity employs a smaller number in Spain, but is taken over those thresholds if you aggregate employees in other jurisdictions? Is that triggered, or is it limited to Spanish-based employees, please?
That's a very good question. I would say it's just for Spanish employees because it's what the legal entity would employ. But yeah, if there is a group of companies for labor purposes, and that means that there's kind of a joint management from company somewhere else, then it could be considered, then the global company should apply. But my view is that initially it should be just the employees in Spain.
Okay, thanks. Over to Lawrence. I'm just conscious of time as we move to minute 36 out of 45. Lawrence, French pay equity reporting.
Okay, I'll try to be quick. So in France, since last year, companies with at least 50 employees have to calculate a pay equity index every year and publish it on their website. It came into force in 2019 for companies with a headcount of over 250, and that's by legal entity in France generally. So how does that work? The index is based on 5 indicators or metrics. Principally, it's based on the gender pay gap, of course, but you also have to score points on number of individual pay rises by gender, number of promotions, whether you gave employees on return from maternity leave a pay rise in line with what other people got during the maternity leave, and also how many women are amongst the 10 most highly paid employees in the company. So you apply these indicators, you get a total score out of 100. And if you score below 75 for 3 years, there's potentially a financial penalty, and it can be quite big, up to 1% of the total annual payroll of the whole workforce. So this new legal framework, it provides a powerful incentive to address pay equity issues, and it gives you 3 years to do so. A month ago, the government reinforced the index rules in 2 ways. First of all, employers must publish not just the total score out of 100, but a breakdown of the score for each of the 5 indicators. And they also now have to do so in a visible and legible way. So you can't anymore get away with hiding it on an inaccessible web page that nobody will ever find. Companies that receive state aid under recovery measures adopted in response to COVID, they now also have to publish detailed objectives and say what corrective measures they're going to take if they score below 75. I think it's a reminder that when President Macron was elected, he made it a key objective of his mandate to address the issue of gender pay equity. So it's a signal that he wants to be seen to be continuing to make efforts to reduce the pay gap. We'll move to our last topic, a very quick look at latest lockdown developments. And of course, this topic by definition is a moving target, so we won't spend long on it. In France, a month ago, the government adopted a relatively strict lockdown regime at national level after previously trying a more regional approach. This is in force until next week, and the key points currently, in case you're interested, basically during the day, in most cases, no more than 10 kilometers travel from home, and even then you need specific reasons for doing so. You can only travel more than 10 kilometers from home for work or for some other overriding reason. There's a daily curfew from 7 p.m. onwards, and you have to carry an attestation, a written declaration stating the reason for your trip. So if you're stopped in the street and asked why you aren't at home, you can't just make up the reason on the spot. So we think some of these rules will be lifted next week. We think that across most of mainland France, there'll be no more daytime travel restrictions, which is good news. Now, quickly back to Spain before we wrap up.
Okay, so in Spain, similar to France, this is changing life, and there's a bit of uncertainty of what's happening. And as I said, the situation actually changes from region to region, similar to collective agreements. So what we have now is a state of alarm declared. The state of alarm allows the government to limit fundamental rights, and in this case, the fundamental right is to free movement. And that provides for the limitation of movements between regions, so the autonomous community can provide for, no one can come from different regions, and also a curfew between 11 p.m. and 6 in the morning that can be anticipated or delayed in 1 hour as per the decision of the autonomous community. And for those of you who are not in Spain, it's funny to see that 11 p.m. is actually quite early if you think about our dinner time. So it doesn't really mean that we have enough time, taking into account that generally we have dinner quite late. But aside from that, the state of alarm is going to finish on May the 9th. We don't know yet if it's going to be extended. Probably not, as of what the press says today, but this can change at the minute. And therefore, after that, it will be subject to the regions to define, depending on the level of infections, what limitations should apply. There's a general mandatory use of face mask pretty much everywhere, and there are strict health and safety protocols approved by the autonomous community, and these are updated all the time. So the protocols from back in July have nothing to do with those as of today in April, so they have to be monitored constantly. In general, the professional reasons are considered a fair or valid justification to skip the limitations that I just defined. So if for professional reasons an individual has to go to another region, that is generally allowed, provided that they carry out a justification, so an attestation that will serve for that justification. So if I have to, I'm sitting in Madrid, if I have to go to Barcelona for work, I should provide a paper in case that I'm stopped by the police or the authorities to prove that I had a valid justification because of a professional reason. Again, this is something that is life-changing, and probably if we talk next week, the position will have changed already. And I think that leads us to the end of the session today. We have some time for questions, Martin.
Thank you, Anna. Yeah, we've picked up a couple of the questions as we've gone along. There are a couple, though, that I think we could maybe just try to knock on the head quickly now. So first of all, I think you were talking a little bit earlier on about home working agreements, Anna, and the question for you is whether the law that generates the obligation to enter into home working agreements, is that already in place? I presume it is, but can you please confirm?
I confirm it is in place. There was a transitional period for its implementation, and especially the obligation to have a remote working agreement was after 3 months from its approval, so it's already enforced because the law is dated back in September. The only exception is for companies that had collective agreements that ruled remote working, and those agreements didn't have a definite timing, so they were kind of indefinite, then the law provides that there is 1 year to implement the provisions of the law. But if there is no such collective agreement ruling remote working, then the parties have to set up this remote working agreement to rule the content of the relationship, the details of the law.
Okay. Thank you very much indeed. And there was a kind of a related question, which Lawrence already answered for France, Anna, as to whether or not there was an obligation to pay a separate allowance or separate compensation for people working from home. Could you just very quickly answer that question for Spain, please?
Yes, there is such obligation. That is actually one of the contents that needs to be included in the remote working agreement. The tools that are required for the work, the expenses and the cost that will be triggered for the employee, and the amount and process for the compensation. Unless the collective agreement sets up a specific amount, then this is subject to the agreement of the parties. So the company and the employee in the remote working agreement will set up the amount that will be paid as expenses for the remote working. If the company has employee representatives, then that has to be negotiated with the employee representatives. And if, as I said, the collective agreement says something in this matter, then that has to be applied, obviously. But generally, most of the collective agreements are silent, so it will be a matter of the negotiation between the parties.
Okay, thank you very much indeed. I'm very conscious of time. We are just 1 minute left before the end of the session. We've got to pretty much all of the questions. I think there are just a couple outstanding. We'll pick those up separately by email tomorrow. So I think I'm going to pass it back. Anna, are you going to read the CLE code, or is Megan going to pick that up for us?
I can read it. So the CLE code you're reading on the screen, that is SS, as it's Seyfarth Shaw, SS3743. Let me read it again, is SS3743. 743.
Fantastic. Okay, well, that covers everything we wanted to talk about today. We are bang on time. As I say, there are a couple of questions that we weren't able to get to. I think that they maybe require a slightly more detailed answer, but I've already confirmed through the chat function we'll pick those up separately tomorrow by email. But thank you very much indeed to everybody who's made the time to dial in, and thank you very much indeed to Anna and to Lawrence for your time. Have a great day, everybody.